and the commission of ballot papers, which is also a process that takes place prior to the general elections, and which in turn affected the elections in the areas that we complain the election was cancelled. She lists it, and for time, I will not refer to them. The averment is that the error is upon, or the chair led to the cancellation of the result, will neglect. Irene Masit further testifies that was required to be before the procurement was done, or verification to ensure that they proofread what they had procured. And she also testified in 2017 this to ensure that this mistake does not occur. My ladies and my lords, to the extent that that admission is made by a commissioner, we submit that we are supported or find corroboration to our complaint that in the areas in which we have complained about was deliberate and not accidental. The fifth issue that I deal with was whether there were unexplainable discrepancies between the votes cast for the presidential candidates and other elective positions. This evidence is found in the affidavits of Celestine Anyango, I beg your pardon. My ladies and my lords, the evidence is found in the affidavit of Celestine Anyango, where she shows at paragraph 8, 9, 10, and 11, where she has produced evidence showing that in 8 counties, there were votes cast for the president, votes cast for the governor, votes cast for the senator, and votes cast for the woman representative. The total number of the votes discrepancy is 208. And my lady, it is at this point that I reiterate again the result declared for the, which is 69,000 votes to attain the 50% plus 1 threshold. In response, the discrepancy of the votes that we have highlighted, the IBC's witnesses, Sunkuli, Moses Ledama Sunkuli, I believe, states that those discrepancies are accounted for by prison votes. Because prisoners only vote for the presidential candidate. My ladies and my lord, if one looks at the total number of votes that have been provided as having been accounted to the prisoners, it is only 715 votes. You will find this at paragraph 53 of Sunkuli's affidavit. There is therefore no account for 32,493 votes. On that issue alone, we would like the court to consider Kirinyaga County, where the discrepancy presidential votes and the governor's votes was 23,550. The only answer given by stray ballots. My ladies and my lords, a rough calculation of what is given as stray ballot for Kirinyaga County alone yields 33 stray ballots per polling station on average in Kirinyaga County, which we submit is not possible. This is also the kind of issue or discrepancy that, based on the rules, ought to have been brought to the attention of the National Tallying Center or the National Returning Officer. We rely also upon the authority cited in our submissions of William Kabogo, where the learned Justice Kimaru said a difference votes between the parliamentary position and the presidential can only be as a result of fraud. My ladies and my lords, would also urge the court to note that at this election, the IEBC had provided clerk whose sole duty at the that voters placed their ballot papers in the right box. And therefore, the incidence of such a high number of stray or allegedly stray ballot papers cannot be explained and has not been explained. Finally, my ladies and my lords, as time is not on my side, we urge the court to look at the evidence of Arnold Ochieng Oginga on the discrepancies between the results declared in Forms 34A, Forms 34B, and Forms 34. The design of the election was that this was to be a seamless. The Forms 34A and the results therein ought to be the same as the Forms 34B and ought to be the same as the Forms 34C. In his affidavit, Arnold Ochieng Oginga finds that there is a discrepancy in the results to the extent of over 180,000 votes. That affects the result of the election or the outcome of the election. I will stop at this particular point and invite my senior, Mr. Paul Mwangi, to continue.
Madam Chief Justice, Madam Deputy Chief Justice, please. I am to address myself to the sixth issue of the court, whether the IEBC carried on the verification goals in accordance with Article 138(3)(c) and Article 138(10) of the Constitution. The thrust of my presentation is that the nature of management of elections in Kenya, from even before the new constitution, have been that decisions as to who has won the presidential election are collegiate. And that the collegiate nature of the decision as to who is the winner of a presidential election goes down to the description of what is a free and fair election under Article 81. And in Article 81E, the Constitution describes a free and fair election as an election, E3, conducted by an independent body, 4, transparent, and 5, administered in an impartial, neutral, efficient, accurate, and accountable manner. And it is my submission that this goes not to just what the Constitution says, but what Kenyans have practiced and what they have come to expect whenever bodies are making decisions. Possibly more than any other body, the judiciary has been able to show Kenya the nature of collegiate decision making. We have had live court sessions from the High Court to the Court of Appeal to the Supreme Court. Kenyans have seen judge, in this case even the Chief Justice, consult even sometimes openly with other judges before the court arrives at a decision on even very small things. And we have even had situations when a decision becomes grave, retire to go so that they come back with a collegiate decision. So that is what we come to expect, and that is also what Kenyans expect even from the Independent Electoral and Boundaries Commission. The nature, our commissions are made up of at least 3 members and at most 9. And if you look at the qualifications of all these members, they are all, whether it have the same qualifications. They are all identified and recommended for appointment among the same criteria, approved by the National Assembly. They are all appointed by the President. So there is no commission can treat as subordinate members of that commission or treat them as if they have lesser qualifications or lesser competencies than him. They all enjoy the same security of tenure. They all enjoy the same security in their remuneration. And so they are all very substantive mandates. My Lord, this question as to the mandates of commissioners came up in the case of Michael the Ethics and of Authorities, came up in the High Court and came up in the Court of Appeal. And the court, both courts were very categorical as to the fact that the constitutional mandate of a commission is borne by the commissioners. And in that case where a position without commissioners, the court and said that that decision had to be made by commissioners. And in response, again, the minor KI case all the way from the High Court to the Court of Appeal and to this court have made it clear that the chairperson is not the commission and that he has to act with the rest of the commission for him to deliver a proper constitutional decision. So that collegiate nature of the decision making in a commission is captured very well in Article 138(3)(c) and in Section 39(1)(c) of the Elections Act, which make it very clear that it is for the Commission to tally and verify the results. And in Article 138(10) is only where the chairman is asked to declare the result of that decision. And our submission is that the requirement does not give the chairman any power to tally, to verify, or even to reach a decision as to what he is going to declare. That part of the Constitution was first captured in Section 41 of our previous Constitution, in subsection 11, that provided any decision of the Commission shall require the concurrence of, and that is why I say the collegiate nature of decision making at the Electoral Commission even precedes our new Constitution. And at that time, there was an attempt, which I will submit is an attempt that has also been made this time by the chair of the Electoral Commission, to take away that collegiate nature of decision-making at the Commission. And if you read the Kriegler report, which is also next to a list, it talks of an attempt at that creation at that time of an office that was called the Supervisor of Elections. And the Supervisor of Elections was an executive office that was used to undermine the independence of the Electoral Commission. As we moved to the first multi-party elections, one of the first insistence that Kenyans had was that the Supervisor of Elections must be removed. Regarding elections must be taken back to the ECK. But that was not even enough, because we felt then that Section 42 and in Act number 6 of 1992, which preceded the first multi-party elections, Kenyans' mandate of the Commission be made clearer, and with 2A into the old Constitution. And Section 42A made it very clear that the Electoral Commission shall be responsible for directing, supervising presidential, national. By the time we were coming to the new Constitution, we had already taken a position that decisions regarding presidential elections have to be collegiate. When the new Constitution itself was being promulgated, there were several options that the framers of the Constitution could have. They could go back to making this the decision of an independent office, as Mr. Afula Chebukati has attempted to act. But instead, they created, for the first time, what they called independent offices, created the DPP, the Auditor General, and Controller of Budget as independent offices, but found it wise to retain the collegiate nature of decision-making as an act of the Commission. The question then we asked is, why is it necessary in the decision-making regarding presidential elections? I say, one, is because it gives integrity to the decision. And the more important a decision is, the more it may require more people to make it. And we see that also in our court system, where it have to be made by 3 in the Court of Appeal and have to be made by 5 at the Supreme Court. And this is even being seen in sports today, that in very important matches, they have even moved away from leaving, and we have now gone to even video-assisted refereeing, so that more people can. That is that important. The second thing is that the collegiate nature secures the independence of the Commission itself, so that you don't have one person who can be in a maybe pressure, and therefore, so long as we know that there are 7 people, we are more confident about its independence. But thirdly, there is of the decision, and this comes from what this court said in 2017. 371, in the case of Raila Odinga versus IEBC, the court says, through which the people express their sovereignty, the Constitution is founded upon the immutable principle in the sovereign will of the people. It says that, in fact, it is the people and they alone in whom all power resides, be it moral, political, or legal. And so they exercise such power either directly or through their representatives, whom they democratically elect in free, fair, transparent, and credible elections. Therefore, whether it be about numbers, whether it be about laws, whether it be about processes, an election at the end of the day must be a true reflection of the will of the people. And I view legitimacy in two ways. That first, it is very important for Kenyans to believe that the decision has been arrived at is legitimate. And the reason for that is because it is in one person. They have been asked, or they have asked to delegate their sovereign authority. So they believe that a decision has been reached that is legitimate is very important. And you see that in Article 131. The political legitimacy of that decision is covered in Article 131 of our Constitution. Because Article 131, he makes him the head of state and government in paragraph A. In paragraph him the commander-in-chief. In paragraph D, it makes the council. And then in paragraph E, it makes him the symbol of national unity. So of all the four things that our president must do, the A is the political legitimacy. And if decisions are arrived at as to who has won an election, and they do not carry with them the legitimacy that is required, then you have somebody who cannot do the duties under 131E as being the symbol of national unity. But there's a second reason. And the second reason is that also the person to whom you now declare as the president must himself believe the decision that has been made. And political scientists say that this political legitimacy is necessary because it finally determines how that person themselves will hand over that power. And political scientists say that power that is unjustly acquired will never be justly given. So if you want to have a legitimate transfer of power in a country into the future, that power is also known not just to the public, but to the person who acquires it as legitimately obtained. The question then comes to where we find ourselves today, and a minority group saying they carry the day in this decision, and we have 4 commissioners. And the question this court has to ask is who would it believe? Mr. Wafula Chebukati has disrespected the Constitution, has been unable to secure the legitimate result. And in terms of deciding who to believe, my Lord, first and foremost, Mr. Wafula Chebukati has not had a complaint to make as to how these 4 commissioners worked ever since they entered the commission in September 2021. On the other hand, there are lists of complaints as to how he himself has conducted this election that start way back from 2017, that he bungled up the 2017 elections. We've captured in a petition that he has had for. There's unilaterally printed ballots. His unilateral registers presented in our both affidavits and petition. We have made a list of all the misconduct that he himself has executed. And the result of all that, you come to the conclusion that what the chairman has attempted to do is to install himself as a new age supervisor of election, totally emasculate the role of all other commissioners, and you now have a decision that is his, supported by a minority of the commission. And our argument is that that declaration is not a constitutional declaration. That declaration is unable to found the declaration that was supposed to be made under Article 131.8. And one of the most conduct is the issue of the 27 constituencies. And the ninth respondent knows the importance of that, because in paragraph 6 of his affidavit, he purports that those results were read. He purports that, in fact, that announced those results of Professor Goulier, and the response of Chebukati themselves clearly say that those 27 constituencies were not verified and announced. According to the four commissioners, is because he emasculated the role of the other commissioners and they never sat down as a commission. I will finish my presentation as to the unconstitutionality of that declaration with two examples. We have had previously a situation such as this in the Truth, Justice and Reconciliation Commission. I will ask the court to take judicial notice of what had transpired as the commissioners fought with their chairman regarding what was the report of the commission. And it was very clear the commission had to be what was decided by. Leave this presentation with something closer home. In the past couple of years, there has been a dispute between of this country and the judiciary regarding who makes the decision as who becomes a judge. And it has been the position of the national executive that the power comes with it with some form of power to decide. And this judiciary has been very clear all the way from the High Court to this court that the power to appoint in no way includes a power to decide on who becomes a judge. I say that for the same reason, the power given BC to declare the result of an election